good morning, good afternoon, whenever you are watching this. This is part 2 of the Messiah unaliving in a New York prison. The guards are up.
People of the state of New York against Caleb Blair under indictment I-2025-090. Are you Caleb Blair? Why don't you walk right up to that microphone?
I am, Your Honor.
And what is your date of birth?
June 6, 1994.
Is that on?
June 6, 1994.
And how old are you right now?
30 years old.
And Counselor, could you state your name for the record?
William Sullivan.
Mr. Blair, the United County Grand Jury has returned an indictment against you. That indictment charges you with murder in the second degree, manslaughter in the first degree, gang assault in the first degree, gang assault in the second degree, conspiracy in the fifth degree, and offering a false testimony for filing in the first degree. You have a right to be represented by counsel in this matter, and Mr. Sullivan, you'll be representing Mr. Blair in this matter.
Yes, Your Honor.
You have a right to a trial by jury, and you have a right to testify at that trial if you so choose. Mr. Patrick, if you would like, you can read the
Thank you, Judge. For the record, Sarah Fitzpatrick, as special prosecutor representing the people, pursuant to indictment number I-2025-090-1 through 10, the people of the state of New York versus Caleb Blair. The grand jury of the county of Oneida, by this indictment, accuses Caleb Blair of the felony crime of murder in the second degree, pursuant to, in violation of section 125.25, subsection 2 of the Penal Law of the State of New York. This is an 11-count indictment. Does counsel waive further reading?
Yes, Counsel.
I know for the record, Judge, that 6 counts do apply to this defendant. Attached to the indictment, I provided to defense counsel this people's standard pretrial notices. Specifically, the people do intend to use identification evidence as well as admission or confession evidence. Similarly, as Mr. Williams stated with the previous defendant, we may be supplementing that 7-10-30 in the future within the next 15 days. However, that does contain a flash drive with many of the statements and identifications that the people do intend to use at trial.
Okay, again, Mr. Sullivan, your receipt of that document.
Judge, I acknowledge receipt of the indictment and the attached notices to the not guilty plea.
Not guilty plea will be entered. Mr. Sullivan, I'm going to adjourn your case, or Mr. Blair, I'm going to adjourn your case until May 23rd at 9:30 in the morning for you to report on any offer made by the district attorney's office. And at that point, if you're not going to accept an offer, I'll give you a motion to schedule at that point. Mr. Patrick, would you like to be heard in regards to bail?
I would, Judge. This defendant has no known criminal history to the people. However, the top charge out of the 6 that he is included in this indictment is the felony crime of murder in the second degree, as Your Honor is well aware. Therefore, exposing this defendant to a serious amount of incarceration period should he be found guilty of such charges. As a result, that does increase the risk of flight, and the people would similarly be requesting, as we did with the co-defendant Levy, bail to be set in the amount of $500,000 cash, $1 million bond, $2 million partially secured bond. But we also would respect Your Honor's decision should you set bail in the same amount as the previous co-defendant.
Mr. Sullivan, would you like to be heard?
Yes, Your Honor.
Go ahead.
Judge, Mr. Blair was born in Rome, lived here in this county his entire life. He was homeschooled by his parents through 9th grade. Thereafter, attended Rome Catholic, and he graduated from Rome Catholic in 2013. He then went on to study at SUNY Poly, got an associate's degree there in accounting, then went on to serve his country in the National Guard, but has always kept Oneida County as his home. He is married with children. He is a member of a local church and is very involved in there. And Judge, I know the court addressed bail on the first case call in reference to statute. There's no risk of flight, Judge, none whatsoever. He's been in contact with me since early March. This incident is alleged to have occurred on March 1. 6 weeks have passed, Judge. I would submit to the court that if he were going to flee, that would have happened already. He has not. He's retained counsel. He's been in contact with me. He surrendered himself to the New York State Police at Marcy this morning. He was told to be there at 11 a.m. I understand he arrived early. As we were advised by the people that the police would be waiting for him. He's not a flight risk, Judge. I would ask the court to set down the amount of $50,000 cash, $100,000 bond, $200,000 partially secured.
The court has considered arguments of counsel, again referring to CPL section 510.10 subdivision 1, specifically factors including the charges facing the defendant, that being top count murder in the second degree, where he faced up to life in prison if convicted, and the factor, did this individual, the allegations involve causing harm to an identified individual. Based on those factors and arguments of counsel, I will set bail in the amount of $100,000 cash, $250,000 bond, and $1 million unsecured bond with a 10% deposit. And Mr. Blair, you have to surrender a passport if you have that. Again, Mr. Sullivan, May 23rd, 9:30 in the morning.
I do have a passport.
Mr. Blair, before you go, I want to go over some warnings with you. Mr. Sullivan has a copy of what I'm about to tell you in writing, so if you just follow along. Mr. Blair, you have a right to be present in court in any proceeding, including, in particular, a hearing and trial. You understand that? You can, however, by your conduct, waive, give up, forfeit, or lose that right to be present. If you disrupt the proceedings, the law permits the court to exclude you from the courtroom, commit you to jail, and continue the proceedings, including a hearing or trial, in your absence. You understand that? If you deliberately fail to appear here for a trial, that will constitute a waiver, a forfeiture of your right to be present. A warrant will be issued for your arrest. The trial will continue in your absence. If there is a verdict of guilty, and you again deliberately fail to appear for sentence, you will be sentenced in your absence, and upon your arrest, the sentence will be executed. You will also be subject to separate prosecution and separate punishment for bail jumping, no matter what happens at this trial, and bail money and or property that is used as collateral will be forfeited. Do you understand that? And you agree to appear at each and every court appearance that you make bail.
I do.
Okay, you just please sign that.
Thank you, Judge.
This is the matter of the people of the state of New York against Francis Chandler under indictment I 2025-090. Are you Francis Chandler? And what is your date of birth?
28.
And how old are you? Mr. Chandler, the United County Grand Jury has returned an indictment against you. That indictment charges you with the crimes of gang assault in the second degree, manslaughter in the second degree, conspiracy in the fifth count, 2 counts of conspiracy in the fifth degree, offering a false instrument of filing in the first degree, and tampering with physical evidence. You've been brought to court to be arraigned today. Mr. Williams, you may arraign.
Thank you, Your Honor. In Oneida County Court, the people of the state of New York versus Francis Chandler, indictment I-2025-090-1 through 10. The grand jury of Oneida County, by this indictment, accuses defendant Francis Chandler of the crime of gang assault in the second degree. Counselor, do you waive a further reading?
Waive a further reading, Your Honor. Good afternoon. I'm pleading not guilty.
Not guilty plea will be entered. Mr. Chandler, in regards to this indictment, you have a right to be represented by counsel. You have a right to a trial by jury. You have a right to testify at that jury trial if you so choose. And Mr. Vadnais, you are representing Mr. Chandler on this matter.
Your Honor.
Again, what I'm going to do today is adjourn this case until May 23rd at 9:30 in the morning, with the hopes that the DA's office will provide you with a pretrial offer and return to report on that offer. And then if the offer is going to be rejected, we'll give out a motion date or motion schedule at that point. Mr. Williams, would you like to be heard in regards to bail?
Yes, Your Honor. And before I be heard, in regards to bail, may I address one issue?
Of course.
Your Honor, we did attach to the indictment that has been provided to Mr. Vadnais our standard 71030 notice, which has our standard pretrial notices as well. Specifically attached to it are notices of identification as well as statements. Also attached to it is a physical thumb drive that contains interviews of the defendant. And like, I apologize.
Oh, no, go ahead.
Like the prior defendants, in regards to the 71030, there may be a supplemental 71030 within the 15 days that we're statutorily obligated to turn over.
And you received that.
Acknowledge receipt of that, Your Honor.
So, Mr. Williams,
Law of the state of New York. Out of this 11-count indictment, 5 charges applied to this defendant. Does counsel waive further reading?
I waive further reading and enter pleas of not guilty to each count, Your Honor.
And Judge, provided with the indictment to defense counsel are the people's standard pretrial notices. Attached to such is a hard drive that does contain video recordings. The people will intend to use both identification evidence as well as confession evidence in moving forward with prosecution.
I acknowledge receipt of those documents, Your Honor.
all right, and you previously entered a plea of not guilty.
Yeah.
All right. Okay, Mr. Berger, what I'm going to do is adjourn your case until May 22nd at 9:30 in the morning for the DA's office to provide your attorney with any pretrial offer that they're may be making. If they do in fact make a pretrial offer, when you come back on the 22nd, I'll ask you to report on whether you're going to accept that pretrial offer or turn it down. And at that point, if you do turn it down, we will schedule motions and go from there. Mr. Patrick, would you like to be heard in regards to bail?
Yes, Judge, based on previous arguments as well as understanding the court's previous bail being set, this defendant is facing charges similar to his co-defendants that have already been arraigned, in which case the people would respectfully request that bail be set in the amount of $75,000 cash, $200,000 bond, $750,000 partially secured bond, as well as having the defendant's passport be taken at this time by Your Honor.
Mr. McDermott, would you like to be heard?
Thank you, yes, Your Honor. I do have Mr. Berger's passport here to provide to the court. I would note that Mr. Berger is 45 years old. He's married. He's the father of 2 children. He owns his own home in the area. He has previously been employed by the Department of Corrections for over 20 years. He has no prior criminal convictions. He appeared today voluntarily, surrendering himself upon notice from the District Attorney's Office yesterday. I would suggest the court imposes no flight risk. And with the surrender of the passport, I would ask the court to set bail in the amount of $50,000 cash, $100,000 bond.
The court having considered arguments of counsel and looking to the factors set out in CPL 510.10 subdivision 1, most importantly, the fact looking at the charges facing the defendant, he is facing a charge of manslaughter in the first degree, which is a Class B violent felony, where the maximum penalty is 25 years in state prison. And also the other factor is whether or not the crime charged caused harm to an identified individual, and in fact it did. With all of that considered, the court will set bail in the amount of $75,000 cash, $200,000 bond, and $750,000 unsecured bond with a 10% deposit. Mr. Berger, I'm going to give you a copy of Parker warnings. I ask you to follow along with those warnings with your attorney. Mr. Berger, you have a right to be present in court and any proceedings, including in particular a hearing and trial. Do you understand that?
Yes, sir.
You can, however, by your conduct, waive, give up, forfeit, or lose that right to be present. If you disrupt the proceedings, the law permits the court to exclude you from the courtroom and commit you to jail. And continue the proceedings, including a hearing or trial, in your absence. Do you understand that?
Yes, sir.
If you deliberately fail to appear here for a trial, that will constitute a waiver, a forfeiture of your right to be present. A warrant will be issued for your arrest. The trial will continue in your absence. If there is a verdict of guilty, and you again deliberately fail to appear for sentence, you will be sentenced in your absence, and upon your arrest, the sentence will be executed. You will also be subject to a separate prosecution and separate punishment for the charge of bail jumping, no matter what the outcome of that trial is. Do you understand that?
Yes, sir.
And you understand if you fail to appear at court appearances, that the bail you posted could be forfeited, and any property used as collateral could also be forfeited. You understand that?
Yes, sir.
And you agree to show up at each and every court appearance going forward.
I do.
See you back here on May 22nd at 9:30 in the morning.
And Your Honor, Mr. Bernardo is here prepared to propose.
Correct. And just, it wasn't stated the defendant did surrender his passport.
Also provided notice of charges.
Thank you. And Mr. Bernard, you swear to the truth of the affidavit?
I do, Your Honor.
Nicholas Vitale.
This is a matter of the people of the state of New York against Nicholas Vitale under indictment county 2025-090. Are you Nicholas Vitale?
Yes,
And what is your date of birth?
7/29/02,
And how old are you?
32 years old.
Mr. Vitale, the grand jury of United County has returned an indictment against you. That indictment charges you with misdemeanor count of conspiracy in the 5th degree.
Judge, good afternoon.
Good afternoon.
Michael Kasmarek, appearing on behalf of Thomas Eck.
All right, just come up right to that microphone just so we can hear you. This is a matter of the people of the state of New York against Thomas Eck under indictment I 2025-090. Mr. Eck, the United County grand jury has returned an indictment against you. That indictment charges you with manslaughter in the 1st degree, gang assault in the 1st degree, gang assault in the 2nd degree, 2 counts of conspiracy in the 5th degree, offering a false instrument of filing in the 1st degree, and tampering with physical evidence. In regards to this indictment, you have the right to be represented by an attorney, and Mr. Kasmarek, you're going to represent Mr. Eck on this matter.
I am, Your Honor.
You have a right to a trial by jury. You have a right to testify at that trial if you so choose. Ms. Patrick, if you'd like to arraign the defendant, you may arraign.
Pursuant to indictment number I 2025-090-1 through 10, the people of the state of New York versus Thomas Eck. The grand jury of the county of Oneida by this indictment accuses Thomas Eck of the felony crime of manslaughter in the 1st degree in violation of section 125.20 subsection 1 of the penal law of the state of New York. Of this 11-count indictment, 7 of the counts apply to this defendant. Does counsel waive further reading?
Judge, we waive further reading, acknowledge receipt of the indictment, as well as the people's notices pursuant to section 71030, and are not guilty plea on behalf of Mr. Eck in each count.
The not guilty plea will be entered on your client's behalf. Mr. Kasmarek and Mr. Eck, I move to adjourn your case until May 22nd at 9:30 in the morning for the DA's office to provide you with a pretrial offer and report on that offer. If the offer is not acceptable at that time, we'll be a motion scheduled at that time. At this point, Ms. Fitzpatrick, do you have any recommendations as to bail?
Yes, Judge. Given the charges that this defendant is facing and the potential incarceration exposure should he be found guilty of them, thus increasing the risk of flight, the people would be asking for bail in the amount of $100,000 cash, $200,000 bond, $500,000 partially secured bond.
And Mr. Kasmarek, would you like to be heard?
Judge, I would. Judge, Mr. Eck is a lifelong resident of Oneida County. He has family here. His mother and father, as well as one of his siblings, reside in the county. He is a graduate of St. John Fisher University. He had been working for the Department of Corrections for about 8 years. Judge, I note that he has no arrests or convictions, as well as no disciplinary actions relative to his employment with the state. Judge, I also note that Mr. Eck voluntarily appeared for 2 separate interviews. He appeared here voluntarily this afternoon. He retained my services prior to appearing here. I'd also note, Judge, that after he was suspended by the Department of Corrections, he promptly went out and found gainful employment. He has a child, a son, that he supports financially that relies upon him. Mr. Eck and I have had many discussions about the facts and circumstances surrounding his case, and I can assure the court that he is resolved to answer these charges and clear his name. Judge, I ask that the court's inclined to set bail, that he set $10,000 cash, $20,000 bond, $30,000 partial secured bond.
Having listened to arguments of counsel and looking at the factors set out in CPL 510.10 subdivision 1, for the record, the defendant, the charges he is facing do have a maximum penalty of up to 25 years in state prison, and the other factor is that this crime did cause harm to an individual that is identified. So with those arguments in mind, the court will set bail in the amount of $75,000 cash, $200,000 bond.